As the appointed facilitator of this event, I hereby declare this meeting sitting of the People's Tribunal of Ireland in session. Members of the meeting and others present are respectively asked to observe silently until these proceedings are concluded. The proceedings before the Tribunal today are the form of an Article 40.1 constitutional inquiry, which article states that all citizens shall, as human persons, be held equal before the law.
Sorry guys, there we are. Pushed up button there. There we go. Teething problems.
The applicant is Stephen Manning, publisher of Ballyhouse, County Mayo, and the respondent is Michael MacGrath, High Court Judge at Four Courts, Dublin. Independent adjudication is by consideration of pre-submitted written statements and by remote observation of these proceedings, with the adjudicator's findings being returned by counsel within 7 days after consideration of any requested evidence. Any prepared in advance adjudicator's questions will be put to the parties before they give any evidence. Is the applicant represented?
Yes, thank you.
Is the respondent represented?
Apparently not.
No. If checks, IDs are authorities of proxies, proofs of postage, services and says both parties have been placed formally on notice of these proceedings and have been advised of their inter-party rights to submit statements, nominate a proxy, enter evidence or call witnesses, and been satisfied that the parties have been duly served. These proceedings will now continue with the reading of the applicant's statement into the record.
As the named applicant in this matter, I, Stephen Manning of Ballyhouse, County Mayo, being 18 years older or older, hereby declare that this statement following, which contains 5 pages and 18 numbered paragraphs, is true to the best of my knowledge and belief, and I make this statement knowing that if it is tendered in evidence, I will be liable for prosecution if I say anything in it which I know to be false or misleading or do not believe to be true. I say that I understand that hearsay evidence is not admissible, and that any and all allegations of fact presented in this statement must be supported by physical evidence that is in the possession of the declarant at the time of making this statement, or is readily available to the declarant, such as can be provided to the People's Tribunal upon request. This evidence to be in the form of documents, or of video or audio recordings, or of items or articles referring, and or by sworn statements of truth by eyewitnesses who must be available for cross-examination on the date of the hearing. I understand that any statement or evidence presented to the Tribunal is open to challenge by any parties named in association with this application, either in writing in advance of any hearing, such as today, or in person at the said hearing, and that should anything said or declared in evidence in this matter be shown to be a contrivance, a calculated falsity, or a knowing deception in any form by any party concerned, that under the false in one thing, false in everything rule, there's a Latin term for that, the person committing any such deception will be excluded from the proceedings forthwith, and any such questionable or compromised evidence provided to the Tribunal will be removed from further consideration in the matter referring, without any right to appeal, save in respect of authenticating with new self-evident proofs or verifications any such excluded evidence. I understand that a hearing in this matter will be scheduled on notice to both parties, given the options to A, participate remotely by video link, or B, attend in person at the nominated venue. I understand that there will be no adjournments or deferments. I respectfully refer to affidavits numbers 1 to 23 inclusive in co-joint judicial review cases 2017-798 and 2018-432 as lodged in the Irish High Court, complete with all associated evidence and exhibits in support of the following facts. And I commit to providing the People's Tribunal of Ireland with any necessary clarifications or proofs as requested in support of the facts where I am alleging multiple breaches of Article 40.1 of the Irish Constitution by the respondent Michael MacGrath acting in his role as an Irish High Court judge, and in the absence of any defence to these charges and or in the failure of the respondent to refute these claims, that the applicant respectfully seeks a determination from the People's Tribunal of Ireland. For ease of reference, I will refer to the High Court case the first judicial review as JR number 1 and the second one as JR number 2. JR number 1 was in train since October 2017. Our efforts to progress that case in accordance with the law and with Superior Court rules had been unlawfully obstructed by various officers of the court from day one. Following a formal complaint letter to Justice Seamus Noonan dated May the 21st, 2018, the case was surreptitiously transferred to Justice Michael MacGrath in June 2018. Travelling with that transfer was an already granted application for attachment and committal against solicitors Maura Tehan from the Chief State Solicitor's Office and Brian McLaughlin from the DPP's office for proven contempt of the High Court for failing and refusing to comply with the directions of Justice Seamus Noonan as per the since disappeared order of January the 30th, 2018. I say that despite many mentions and requests and affidavits and oral discussions in court, that at no point did MacGrath J ever move to progress those valid applications. I say that I had also lodged a Rules of the Superior Court 40.1 application. This is different. This is 40.1 of the Constitution, but they have rules up in the High Court that just purely by coincidence are also numbered 40.1. Okay. I ruled an application to cross-examine one Raymond Briscoe of the DPP's office for lodging 2 fraudulent and perjurious affidavits on April the 5th and June the 29th, 2018. Those applications were granted by Justice MacGrath, but despite multiple and repeated requests, no date was ever scheduled for a cross-examination hearing. I say that on June the 1st, 2018, I lodged JR number 2, which alleged a conspiracy by between 8 and 14 individuals involved in JR number 1, who were attempting to prosecute me again on false charges in the District Court. JR number 2 then was joined to JR number 1 by order of Justice Michael MacGrath on June the 7th, 2018, and both cases travelled together thereafter. JR number 2 relates to a District Court case that was initiated in Castlebar in 2018 and then transferred to Belmullet, County Mayo. A stay on those proceedings was granted by MacGrath J on June the 7th, 2018, and then renewed again on July the 3rd and July the 5th until further order of this court. In other words, there is a High Court order stopping those proceedings going ahead. Okay? So it's very important that you understand that bit, guys. You see what happens next. From that date, therefore, there was a High Court order blocking those proceedings from advancing, while JR number 2, which was now joined to JR number 1, progressed. 2 more fraudulent and perjurious affidavits were then lodged in JR number 2 by one Gerard McEntee, a sergeant of Garda Síochána, who is now an inspector. An application to cross-examine McEntee on those fraudulent affidavits was lodged and subsequently granted by MacGrath J. But again, despite multiple mentions and requests in affidavits and in oral hearings, no hearing date was ever scheduled for those cross-examinations. On April the 3rd, 2019, after some 20 plus protracted hearings in a purported application for permission for leave to apply for a judicial review. This was only the first stage of an application. It went for over 20 hearings, guys. MacGrath issued a judgment unannounced in JR number 1. He didn't even tell me about it, he just read it out in the High Court. It was not only a totally misleading contrivance designed to misrepresent the facts of the case and cover up state-sanctioned wrongdoing, but which also quoted directly from the perjurious affidavits of Raymond Briscoe, which were still subject to pending cross-examination. This was an open violation of Order 40.36. There's an order up in the courts, guys, that says if anyone puts an affidavit in a court case, the opposite party has the right to apply to cross-examine them because it's evidence, right? So as soon as these affidavits went in, I said, this is appalling what they're writing, all the lies. And I applied to have them cross-examined. I was granted permission. While you're waiting for that permission and while you're waiting for that hearing to cross-examine, the judge cannot make reference to those affidavits. But that didn't stop MacGrath in this case, okay? He went ahead and issued a judgment based on those fraudulent affidavits without giving me the opportunity to cross-examine, yeah? Even though he granted me permission to do it. This is the sort of nonsense that's going on all the time. MacGrath then also unilaterally altered the title on the proceedings on April the 3rd, 2019, absent any application from either party in the case to do so. This is a violation of Order 84.22, etc., etc. MacGrath thereafter refused repeatedly to correct the record, despite being informed that his actions amounted to a criminal fraud on his own High Court, and that criminal complaints and proceedings against him would have to be taken according to law. I say that the result of this unlawful, unilateral changing of the title of proceedings from the original, which was Stephen Manning versus Circuit Court Judge Sean O'Donovan, to Stephen Manning versus a judge of the Circuit Court, it has in effect created two separate case records and has prevented any otherwise valid appeal to the Superior Courts or to the European Union because A, the title doesn't match the appeal notice, and B, because we cannot now exhaust all domestic remedies before applying to the European courts because JR number 1 has been effectively suspended and made unprogressible via this fraud. As of the date of this statement, the former title still remains on the Irish Court Servant records, but the latter title is quoted in context of the fraudulent judgment of MacGrath that accompanied it on UK and European databases, as if the application for JR number 1 is in fact overdone and dusted. It was never properly dealt with. But if you read the records now abroad, it's like it's all been done and over and done with. I say that in the 2.5-year period between the issuing of the High Court stay on the proceedings in Balmullet in July 2018 and up to December 2020, that the DPP's office, in conjunction with the court service and other parties to the case, attempted to advance those district court proceedings on some 8 different occasions, in flagrant violation of the said High Court order and in full awareness of its existence, due to me quoting the same as grounds for refusing to attend any such hearings in Balmullet. So I kept refusing to go. They were sending me Garda notices, come to court, and I'd say no, because if I did, I'm participating in criminal activity. You're violating a High Court order, right? Nevertheless, 2 orders issued out of Balmullet District Court ordering me to attend a hearing on March the 10th this year. Now armed with documentary evidence of contempt of the High Court, I applied to the High Court for orders of attachment and committal naming District Court Judge Fiona Lydon, Garda Inspector Gerard McEntee and DPP Claire Loftus. And a hearing in this matter was held before Justice Charles Meenan on March the 9th this year, where he directed, untruthfully, that this matter must go back before Justice Michael MacGrath. For future reference, we note that Claire Loftus and Fiona Lydon did not turn up at that hearing and they did not send legal representation, thus committing yet another contempt of the High Court. This was neither noted nor sanctioned by Justice Charles Meenan. I say that I immediately corresponded with Justice Michael MacGrath by formal letter seeking how to possibly advance our applications for attachment and committal in JR number 2 in circumstances where MacGrath had been formally proscribed and excluded from further dealings with us due to his prior criminal actions and the pending criminal proceedings against him here at the CCJ. I say that without any application by any of the parties to these cases and without any formal notification to me as the applicant, that Michael MacGrath unilaterally declared a sitting in JR number 2 for Tuesday, May the 11th, 2021. I say that we amended our already served notices of motion for attachment and committal from March the 9th and re-served them on all parties to the case, including on the Central Office and on Justice Michael MacGrath in person, in advance of the May the 11th hearing, complete with a notice of conditional appearance, and we attended the High Court with scores of witnesses, 7 of whom entered the courtroom with us. And some of you guys were there that day. You'll remember that's when we all put armbands in and went in as a group. For future reference, I say that our notices of motion and other papers as served on the Central Office in advance of that hearing were unlawfully held up by one Mr. Colin Shortall, who works in the Central Office down there, so as to prevent any stamped and filed reserved originals from being available to us, and that we have documentary proofs and an audio recording to substantiate this. Those documents were then returned in the post to us, unstamped and unfiled, dated May the 11th. That was the day of the hearing. Do you remember, guys? Yeah. So they had them in the Central Office. I told them I was up here on the Monday, the day before, said, just give me a text, I'll come in and collect them. And they pretended not to have them. But the idiots returned them in the post with a cover letter with that day's date on it. So we know they had them. So I know it's laughable, but it's criminal. It's criminal. And as a result, my applications to the High Court couldn't be brought into MacGrath. But they were already valid anyway. And the rest of you know what happened with that. I say that, sorry guys, I say that the said hearing never lawfully commenced because Justice Michael MacGrath tried to prevent me, as the applicant and the first speaker, from addressing the court. And when I then began reading out my notice of conditional appearance into the record, he unlawfully abandoned the courtroom. That these are facts proven by the witnesses and the audio recordings. I say that at 8 minutes past 11 on the morning of Tuesday, May the 18th, 2021. Now you might find this hard to believe, guys, and bear in mind, this is my case, right? I'm the applicant. Nothing should be happening without me knowing about it, at the very least. And usually it's on my own motions, okay? So at 11:08 on the morning of Tuesday, May the 18th, 2021, I was alerted by an unsolicited email from the central office that despite no notifications or advices to me as the applicant whatsoever, that MacGrath J had, it was claimed, read out his judgment electronically in JR number 2, and a plain copy of that purported judgment text was attached, as reported upon in the Irish Times and in other mainstream publications that same day. Now, last page, guys. And those of you that aren't aware of this, please understand, what happened was an article was placed in the Irish Times where they claimed that their reporter was in the court and had listened to the High Court judge read out a judgment in my case, and as a result the case was over and done and thrown out, and I wasn't even told about it, right? Apart from it all being completely unlawful. The reporter didn't check the evidence, she didn't even call me and say, you know, why weren't you there, or, you know, it's all ridiculous. Notwithstanding the contested contents of that contrived text, and the disturbing fact that the Irish Times, a non-party to these proceedings, was privy to a purported judgment which they deceptively claimed to be an accurate rendition of what was read out in the High Court, my application to the People's Tribunal for a determination that my Article 40.1 rights have been repeatedly violated hinged primarily upon the following facts. And I've got 5 of them here, guys, okay? Number 1, that my right to proper procedures has been irreparably breached inasmuch as MacGrath J has improperly moved to issue judgment in both JR cases, whilst live applications to cross-examine witnesses on their perjurious affidavits under Order RSC 40.1 remain granted but not processed, and that he then quoted the contents of those fraudulent affidavits and or made reference to the same in open violation of Order RSC 40.36. Number 2, that he allowed proceedings to continue for 2.5 years, absent any response to my original grounding affidavit and submissions. Now, again, I should clarify this, guys. When you lodge a court case, you know how it works. You put in an affidavit. It's called the grounding affidavit. This is why I'm coming to court. You know, this has happened and I'm not happy about it and I want a result. The opposition then gets a chance to respond to it, yeah? And they have to. If they don't, the case is done. You win by default, okay? Now, the judges might complicate it by saying, I want you now to put in submissions, which means a load of convoluted quotes and legal case law and all that sort of stuff. My original grounding affidavit and my submissions were never, ever responded to in 2.5 years. And they allowed this travesty to continue, okay?
No more.
No, exactly, yeah. So he allowed it to continue for 2.5 years, absent any response. Sorry, let me change hands here again. Sorry. Absent any response to my original grounding affidavit and submissions in JR number 1, and he allowed out-of-time general affidavits containing hearsay in violation of orders 40.4, 40.8, and 40.225. Number 3, that he has moved to judgment unlawfully, absent notice, whilst live applications for attachment to committal in both JRs naming agents of the state remain unprocessed. Number 4, that numerous acts of fraud, deception, criminal damage and contempt of court by various officers of the court have not only been completely ignored by MacGrath J throughout, as detailed in my affidavits and formal complaints, but indeed have been actively facilitated by Justice Michael MacGrath's brazen contempts of his own court. And number 5, that all of this has occurred notwithstanding all of the additional evidence of repeat systemic violations of the law and the Constitution that have been visited upon me personally in context of these co-joint cases, as part documented in the publications, number 1, Criminality in the Irish Courts and the Absence of the Rule of Law, and number 2, Indictment and Petition for a Public Inquiry into State-Sponsored Criminality in Ireland. All right, that's the little black booklet, okay? So the final paragraph here, guys, that I hereby declare that Michael MacGrath, the respondent in this application, has gravely, serially and criminally abused his role and position as a High Court judge in the conduct of these proceedings, displaying overt bias and favouritism towards state actors and extreme prejudice against this law-abiding litigant, in variously facilitating and or ignoring multiple violations of the law and of due process by the opposition, whilst concurrently denying justice and due process to this applicant, In so doing, he has not only committed multiple offences against the administration of justice and openly scandalised the courts, but he has clearly violated my Article 40.1 rights to be treated equally under the law. End of statement. And we'll now go back to the hearing facilitator. There's just one more little segment. You'll see how this is working, guys, okay?
Is there a responding statement or any rebuttal of this claim?
Is Michael MacGrath here yet? No? No, I'm afraid not. No.
Okay, so we'll go on to the adjudicator's questions. I'm just going to read out them now.
Yeah, if you do them one at a time. So the adjudicators have sent in some questions based on that statement, guys, all right? And the whole point now is, you see how simple the procedure is when you compare it to what we go through in the courts. I and the respondent both get a chance now to answer these questions, so that the adjudicators they will get the video footage now of the statement, which they already had, and the answers to the questions before they come to their conclusion in about a week's time. All right, nice and clear. And the good thing is you all get to see what they see. Yeah? Okay.
Adjudicator's question number 1. Have you sought a Gary Doyle order in the district court in retrospect of JR number 2? If so, what was the outcome?
Oh yeah, sorry, I know it's a bit. If I come in front of you for a second, yeah. We'll just swap positions. Yes, he's asking if we sought a Gary Doyle order. If, for those of you that may not know, a Gary Doyle order is the standard procedure when you want disclosure, or what they call discovery, from the opposition. Okay, so you're charged with something and you say, well, I want to see the evidence against me. All right. So yes, I did seek a Gary Doyle order from the district court, and the short version of the story is that they claim to have video evidence of me allegedly assaulting, a court service staff manager. He was behind a counter. I told him, go and get my goddamn file. I was getting irritated with him, and he, if you knew him, you'd understand why. That was my exact words to him. Go and get my goddamn file, Peter. Stop wasting my time or something. That was enough for them to come up with, after the fact, literally 9 months later, out of time and everything. So I asked for the Gary Doyle order. They claimed to have video evidence of me threatening to hit him. It didn't happen, so I knew they didn't have it. So I asked for it. They sent me a CD with 4 photographs on it, me standing at the counter talking. And then I told the judge they haven't complied with the Gary Doyle order. And the inspector said, oh, we did, Judge. I said, I'm telling you, they didn't. Here's the disc. Look at it yourself. I've got 2 IT experts who will tell you there was never any video on this disc. Either give me the video or throw the case out. And the judge turned around and said, I believe the inspector. That's the woman that I went to the second JR against, Judge Deirdre Gearty. Yeah, I'll stand behind you.
Please elaborate on co-joined JR 1 2017 to 798 and 2 2018 432. Are a co-joinments usual? Are they very helpful? Are they agreed by both parties?
You get used to it after a while. To put the question more simply, he's asking why were the JRs joined? Yeah, and is it normal for this to happen? Well, to be fair now, High Court judges have the discretion to manage cases. They can put 2 or 3 cases together to make it easier to manage if they want. So the fact that he co-joined them is not suspicious. Well, it's not suspicious in and of itself, not until you realise that I would turn up to court one day, I'd be told that we were going to deal with one of the JRs, and I'd arrive with all my stuff. You can imagine, literally a trolley load of files and everything, and then they'd deal with the other one, and I'd be unprepared. There was an awful lot of, I believe it was designed to obfuscate and make matters unmanageable, So it can be done, but once they were joined, they were never unjoined. But he tried to unjoin them unlawfully by separating them and dealing with them as 2 different entities.
How is it that after the JRs were co-joined, JRs that number 2 can progress as a stand-alone JR? Is this possible or is it lawful?
Okay. Same question. Once the JRs are joined, the judicial reviews, the 2 cases are joined together, can they just separate them? And, well, usually what happens is that an applicant, or let's say a litigant in the court, has to make an application to the court. If you want anything like this to happen, you apply to the court, you say, will you please join these two, and then the opposition has a chance to object and all that sort of stuff. This is MacGrath just doing what he wants when he feels like it, without me or the DPP asking for it to happen. He did this all the way through. Whenever he felt like it, he just threw another spanner in the works. Okay.
At paragraph 14 of the applicant says that MacGrath declared unliterally, please elaborate on this, its practicalities and the rules pertaining to such procedures.
Right. Can I see that again? Sorry, just unilaterally. Oh yeah. Oh yes, that's right. I say in the statement that MacGrath did this and he did that unilaterally. That's the point I was just making. High Court judges have got a lot of discretion, of course, in what they do, but they can't, for instance, change the title on proceedings without there have been an application for it, or at least without giving us warning that he's about to do it and seeing if we have an objection to it. He just did it. So this unilateral changing and breaching of rules, no, they can't do it, not lawfully.
At paragraph 17.2, line 3, can the applicant elaborate on the RSC 40.4, 40.8, 40.225?
These are the orders that we said that they're violating up in the High Court. The first order is the one that allows a person to cross-examine the affidavit of somebody else. That's a rule, okay? And if they make the application, the judge cannot refer to the contents of those affidavits, obviously, because if one party say, no, it's a bunch of lies, and he just completely ignores them and goes ahead and quotes the affidavit. See, the trouble is the affidavits were coming from the DPP's office and from a member of Garda Síochána who was working under the DPP's directions. So the judge basically would say, I'm going to quote these things. I said, but they're all lies. So he granted me permission to cross-examine, but then never facilitated that cross-examination, and then just moved ahead and quoted those fraudulent affidavits in a fraudulent judgment. Okay, you understand, guys, don't you? What's wrong with this? Yeah.
Questions from adjudication number 3. What safeguards are there to ensure the evidence statements are factually true and correct?
Oh yeah. Yeah, this is interesting, guys. So how does the tribunal check that these statements are accurate and true? Well, that's why we use the tribunal, guys, the council. So in other words, when an applicant makes their application, it goes to the council first, and they have an investigations division, and they basically check it out and maybe communicate with the applicant. If there's issues in it that need clarification, the evidence is sent in, right? Then if the adjudicators want to see the evidence, they don't contact the applicant, they contact the council. All right, so there's a separation in ideal circumstances. Do you understand that, guys? Yeah. So it's the council that's checking the quality of the papers and everything, and the adjudicators, if they have a question, they put it to council. Council then contacts me or whoever it might be. Okay.
If criminal offences have been identified, will the PTI take any further action?
Is that the last one, is it?
Yes.
Yeah, this is the last question, guys, from the adjudicators. I think I mentioned this earlier. If the adjudicators identify, which I would hope they do, criminal offences that have happened here, offences against the administration of justice and that sort of thing, I can then use the documentation I get from the People's Tribunal to lodge applications here or complaints within Garda Síochána, or even take a civil claim for damages, right? Think about it, guys. One of the things we're encouraging people is, once you've discovered you've been offended against by an agent of the state, price your crime. Price it. Put a price on it. What does it cost you? Put a value on it. And that also opens up an avenue to a small claims court as well. Because a lot of this is about turning the system back in on itself until the people that work for the system start doing their jobs fairly and correctly. It's really that simple, guys. We're pushing for reform. We prefer not to have a People's Tribunal, but until they reform or change their ways, we've got to have some other alternative to what's going on. Okay? Thanks.
Now we're going to look at the oral response from the respondent. Not here?
He's not here,
okay.
no.
So the applicant's concluding statement, please.
Well, I don't think I need to do a concluding statement now, guys. It's all here. The idea of having this exchange, if there was any arguments on camera between the two parties, now would be the time to wrap up, and we limit that to 2 minutes. Okay? So everything, the whole point, and I know we've run on a bit extra here today, but the whole idea is that the whole thing gets done in 40 minutes from start to finish. Okay? It's over and done with. one set of papers, we wait a week, the adjudicators send their findings back to council, and then council issue the documentation. That's it. It's over and done with. All right. No repeat returns to the court. No bucketfuls of documents and everything that you have to deal with. Okay. Nice and simple. All right. So, is that you? Is that you?
Yeah.
Oh yeah. Okay. Yeah. Read that. Okay. Thank you.
This concludes today the sitting of the People's Tribunal. The adjudicators will now respond to these findings to the PTI Council for formalisation and publication. Those present will wish to sign up to the PTI database. Please fill in the forms provided. Thank you to everyone for coming today, and thank you for everyone for participating. Thank you.